Welcome to the British Landlords Association YouTube channel. Please click the subscribe button so you can keep up to speed with important landlord-tenant issues. When to use a Section 25 notice and when not to use one. Section 25 notices under the Landlord and Tenant Act 1954 are critical tools in commercial property management across England and Wales. However, misusing or misapplying this notice can lead to costly delays or legal disputes. Understanding when to issue a Section 25 notice and when not to is vital for landlords seeking to manage lease terminations or renewals effectively. A Section 25 notice is a formal notice served by a landlord to a business tenant under a commercial lease protected by the Landlord and Tenant Act 1954. It is used to either propose a new lease or terminate the lease and oppose renewal. It must be served not less than 6 months and not more than 12 months before the lease end date, and cannot be served before the contractual term ends if the lease has already expired and is holding over. If a landlord wants the tenant to stay but on new terms, a Section 25 notice must be served proposing those terms. This preserves the landlord's position and initiates the statutory lease renewal process. For example, if a landlord wants to increase the rent from £30,000 to £35,000 per annum and reduce the lease term from 10 years to 5 years, serving a Section 25 notice with the proposed terms is the correct approach. A landlord may oppose lease renewal only on specific statutory grounds, such as the tenant's failure to repair, persistent delay in paying rent, other substantial breaches, suitable alternative accommodation available, tenancy created by subletting only part of the property, landlord intends to demolish or reconstruct, or landlord intends to occupy the property. In such cases, a Section 25 notice must state the grounds of opposition clearly. For example, if the landlord intends to redevelop the property, issuing a Section 25 notice opposing renewal is essential to initiate the process of ending the lease. A Section 25 notice triggers the lease renewal process under the Act. If the tenant does not agree to the proposed terms or opposes the termination, either party may apply to the court for a decision. If the tenant serves a Section 26 request, the landlord cannot issue a Section 25 notice afterwards. The landlord must instead serve a counter notice opposing the tenant's Section 26 request within 2 months. Serving a Section 25 notice after a valid Section 26 request will be invalid and may prejudice the landlord's position. If the lease is contracted out of the Landlord and Tenant Act 1954, the tenant has no automatic right to a renewal. A Section 25 notice is unnecessary and irrelevant in such cases. Review the lease terms to check if it is contracted out before serving notice. Where both parties agree to terminate the lease or renew it informally, a Section 25 notice is not needed. A formal deed or agreement can be used instead. Section 25 notices must be served 6 to 12 months before the lease expiry or proposed end date. Serving it too early or too late will make the notice invalid.